just out of interest, right? Think about this, and I'd like Vin to talk as well, right? But let's just use your figure, Fabrice, of 10%. Yeah, 10% of people fight it. Yeah. What about 15 or 20% of people just object to it? Do you reckon that's it? That's over and done with.
The system would fall apart overnight. The system would literally overload overnight, and they couldn't cope with it.
Yeah. So basically, if we can get it to that point, say per se, is we don't even need a fight. We're just going to say no. That's it.
Yeah, and I think a part of it is and we've been doing a chunk of this, Brad. I know Vin and I have been working on it at different times, and I know Vin's given me some great resources, which hopefully we're going to put together. Together with some of the clips that we've done, that can hopefully put a few of those resources there, so that you can make sure that people are in a position to empower themselves for that to be an option. Because virtually everybody who I meet, and I say, well, actually, this is how I deal with that. They haven't come across it. They haven't come across that jurisdictional challenge, and so it's making that as easily, understandable as possible, I guess.
I think that's right. Yeah, because the thing is with challenging jurisdiction is, it's not just them claiming that they can. It's not trying to get them to prove that they're a cult as such, and that they're proper judges, and that they're sitting on their oaths and all this sort of thing. Sorry, who's that thing coming in?
Yeah, sorry about that. I'll just mute out. Sorry, guys. I'm eating. Sorry.
Yeah, so that's not what it's about when we challenge jurisdiction. The thing is, their jurisdiction is meant to be based on them having a valid complaint put before them, or grievance. And it's got to be a valid grievance. It can't just be based on something, on anything less than a or it can't simply just be based on an accusation. That and that's why we're challenging the jurisdiction. The people who are sitting there in judgment over you should understand this. That it's not enough just for someone to come along and accuse you. There's got to be a bit more to that, and they've got to be able to do their homework and look into that, and ultimately what it is, it's about them justifying themselves. It's about the accusing party justifying the accusation they're bringing against you, and it's about them justifying forcing you to be there in the first place to answer it. So that's why we challenge jurisdiction. That's why it's so important, and that's something. I mean, obviously,
the problem is, Vin, right?
Yep.
This is the problem. But I love the presentation you put across in relation to jurisdiction. The problem, and this is where it makes it so clean for you, is if they've got no jurisdiction, that's the end of everything.
Well, not exactly, because they've got the guns, they've got the public relations. Essentially, it is, but then you have to take your common sense approach and apply, their rules against themselves and hold them to it.
Bear with me 1 second, Fabrice. Hold your thought. Paul, you've just joined us, right?
Hello, Bradley. How you doing?
Yeah, good, mate. I'm just learning with this stuff. Jason, are you here?
I'm here.
Okay, wicked. Okay, Fabrice, carry on, mate.
I was just going to bounce back to Vin, because the process that Vin was talking about is exactly the right way. But in terms of you saying, well, it's over. Well, essentially it is, but you have to keep it, as you say, common sense, and going back to that essential element. So always effectively reminding them that they haven't established jurisdiction yet, and you're there in good faith to get this matter resolved.
But this is what I'm saying, right?
With your inner Forrest Gump.
I love that line, by the way. I love that line. But this is what I'm saying, right? Vin will walk into, and obviously Vin, right? It doesn't happen, right? In you told me this. You got fucking personally attacked in court. But essentially, what Vin's saying is, walk into court and say, "Please, can you prove to me you got jurisdiction?" And they can't.
Yeah. Well, the one you put it on is the one who's got the burden of proof there anyway, and that's that's the prosecution. That's whoever's attacking you. That's who's got to prove it, not necessarily the court. The court are not the people who are sitting there in front of you claiming to be a court. They don't have to prove they're there for a particular reason other than have to justify why they're there.
Yeah, but how many
That's
times
why
have you
it's
seen
tackling, yeah.
judges look after prosecutors, mate? Come on, I'll fucking...
Oh, absolutely. Yeah, of course
yeah.
they do. Yeah, and that's what you're trying to point out, because then straight away, right from the get go, it's what's called what they call an abuse of process. So yeah, you do use their rules and regulations against them, because it's even they admit if they can't justify themselves, if they can't prove there's a valid case there, and therefore they at least just have jurisdiction to hear the case. That's all jurisdiction really means in this sense. This is what they call subject matter jurisdiction in the court. You know, in the American courts, we don't really have a word for it over here, but what it means is that they have the ability. It's being taken to the right forum for them to hear the complaint. That's it.
Okay, listen, Vin, right?
And
Sorry, Fabrice, just bear with me 1 second, yeah? We know they cannot present evidence of jurisdiction, full stop, yeah?
Mm-hmm.
In terms of evidence. I'm not saying they don't have it.
Yeah.
But why do you then start talking about, well, what about this, what about that, when they can't even prove jurisdiction? The reason why I'm saying this is I know that argument would not work in court.
No, well, see, the thing is you have to give them a chance to prove their jurisdiction. So you have to say, you know, as you know, you say, I'd like all your evidence. I'd like any witnesses and any evidence that you wish to bring against me, including evidence of jurisdiction, evidence of the applicability of the law, and evidence of a complaining party. With those added to, you know, whatever other evidence that they feel they want to bring forward, that should be enough to move their process along, to get it ejected on the fact that they're not going to do that. The fact that they can't prove jurisdiction, they won't admit, so they will find another element of that package that you've given them enough of to throw it out on, to get it. So, you know, we were going to have a cop that was going to come along and explain all about that jurisdiction and stuff, but you know what? He never turned up for court. You know, we weren't able to get you his witness statement in time. And that's practically, in real terms, how it works. Because as a litigant in person, if you can establish a solid jurisdictional challenge, so if you can lay out your reasoned process of why you require that, get the consent from the bench that you're innocent and innocent of every element of the charge, and that jurisdiction is an element.
Here's a question, right? Vin, what's the point of asking about jurisdiction if essentially you know the answer anyway?
Because you're pointing out the fact that they don't even understand what jurisdiction means themselves. They just assume it means they can hold you against your will and force you to answer to somebody else's complaint. And what it also means is obviously that they've already found you guilty as far as they're concerned. So you're there to try and either prove your innocence or prove that they've cocked up somehow, and technically they have to let you go. That's what.
Okay. In practical terms as well, you know, the reason is, you know that, I know that, Vin knows that. Okay, we can say it in a courtroom, doesn't mean anything.
Okay, listen.
Get the judge to say that.
Yes.
Yeah, or get the judge to ask the question of the prosecution, who has the burden of proof if they're bringing the charge. Now, once he says that, the dynamic is very different from you saying that, or me saying that, or Vin saying that. Okay. That's how it works in practical terms.
Okay, listen, right. This is what I'm getting to, right? Is what? Okay. Let's just use Vin's approach here. On the base, and Fabrice, also, you're in agreement in tandem with him, which is fine, right? Is question number one, jurisdiction. You've got no jurisdiction, you don't need to be there. Why don't you just walk out the fucking door?
Because you know that they won't stop the attack regardless.
Okay, so why ask the question then?
because you point because you're trying to get them to point out the contradiction. You know it's complete bull, but you've got to get them to admit it. There's no point. It's like Fabrice just said. There's no point you accusing them of anything. You've got to get them to accuse them. Basically, put their own foot in their mouth.
Yeah. Okay.
This is why
could you say that is a meeting of the minds? If they agree with you that they haven't got jurisdiction, that is a meeting of the minds done, which means a done deal.
Effectively, what they say, Jason, is that they believe that there's enough prima facie that the prosecution should, within a reasonable time frame, be able to provide that evidence. And it's only when they can't provide that evidence that the matter can be resolved. Okay, up until then, you're just kind of there on your good grace.
What I mean by that is Vin is saying, like, Bradley's asking Vin about why be there to challenge the jurisdiction, why make them say it. Is that because that is a meeting of the minds? If they can't prove it and you're there in person and they actually agree that there isn't any jurisdiction, that is a meeting of the minds.
Well, not a meeting in the minds in the sense of it's now we agree because we're all of the same opinion. It's a matter of them putting the facts down. You can only agree on something once the facts have been laid on the table.
Right.
Then obviously you can agree. So that's a meeting in the minds. It's only a meeting in the minds if you're both at the same map of the world, in terms of what facts are.
Right.
Yeah, so that's what you're basically alluding to. And I think the reason why you're challenging it to begin with and you're asking for jurisdiction is that is the basis on which they're forcing you to be there to begin with. They believe they have jurisdiction. Well, what facts is that belief based on? Now, the reason you ask the prosecution is, or the reason you ask the court is, what facts as a prosecution, my complainant, given to you to prove that you can hear this case?
But in theory, right?
And
in theory, using that, right?
Yeah.
I'm suggesting possibly dispose of that jurisdiction question in.
Yeah, but it's going to be obviously that. Yeah, they're not going to. They're just going to ignore it and just push past that.
Guys, I'm learning on this.
You're not us off again. Keep your fingers away from the key.
Yeah. That was fucking Dean's fault. But what I'm saying is, right?
Mm-hmm.
Is there a way? I'm just thinking about mindset moving forward to help other people out, and I just want I want your opinion on it. Right? Let's just say you go to the judge and question jurisdiction. Can I have facts and evidence? And he says, "Yeah, I've got jurisdiction." Blah blah blah. Gives you all the nonsense that you're going to get. Yeah. Why do you not just then say, "We haven't proved anything to my satisfaction," and fucking walk out the room?
Because then they'll probably schedule a case management hearing and move it on in your absence.
Okay, so fine. So that's what I'm saying.
They're going to continue the attack, and you know that. So basically, you're being forced there. You're being forced there right from the start. They can't justify why you've been forced there to begin with, and then they're going to continue whilst you're trying to challenge just that alone.
Yeah, but so fine. That's what I'm saying.
Yeah.
That question in the get-go ought not to be asked.
Well, the thing is,
you should ask it because jurisdiction is the basis on which you're being forced there. It's not the complaint; it's the jurisdiction. It's their alleged justification and ability to force you to be there to answer that complaint around that word jurisdiction.
Yeah. Okay.
It also makes
because
it
they
harder.
believe they have the right to do that. Well, go on and justify it, and that's why you attack it right at the start.
It also makes it harder for them to stick in the dock, I guess.
But why not go in with a
until they've established jurisdiction? If you want to, feel a little bit more comfortable in the court, I guess you can force the issue. But in terms of that, and it's also, why make them think that they have you there at their will when, actually you're not there at their will. When they give you the facts and evidence, okay, to summon you to one place or another, then maybe you do. But If you don't have a tattoo saying "Property of Her Majesty's Government," you haven't sold yourself into slavery, then actually they've got to prove it.
Ben, what were you saying?
See, the thing is about being taken into court and a case being heard before them is the fact that it shouldn't have to get to the point where it has to be proven later on down during the case, during the hearing, that actually they never filed a valid claim against you, or that they missed some evidence out, or they cocked something up along the way. And then the court realises, well, there was never a valid case there to begin with. That has to be established before you even start. And that's the reason you're challenging jurisdiction right from the get-go, because it shouldn't be a case of you should have to be forced to sit there for an hour, or somebody accuses you of something and then evidence comes to light that actually they cocked up, they never had a valid claim there to begin with, therefore you should never have been there in the first place. You shouldn't have to go through a hearing to find that out to begin with, because what they've basically proven is that they never had jurisdiction to hear the case from the very beginning. They never had a right to force you to be there right from the start.
Okay.
And that's why you challenge it right to begin with. Because the thing is, if it goes to appeal, and then you say the very first thing I attacked was jurisdiction, and here's the reason why, because as it turned out later during the appeal, I was asking for facts for A, B, C. They wouldn't provide them, therefore they couldn't establish there was a valid case there to answer to begin with. Therefore, they never had jurisdiction, and that's what you can show in the appeal, and that's why it's important to attack it right from the start. Yes, they're going to push past it and railroad you and try and ignore it, but it doesn't matter. What you're doing is you're laying what's the point? You're racking up the bad points against them. Everything that they're doing wrong, all the abuses, you're racking them up against them.
What about if you're a litigant in person?
Well, it's the same thing.
Same thing, yeah.
Yeah, you still ask for facts proving jurisdiction. See, and the thing you pointed out is that they don't really understand themselves what jurisdiction means. They just simply assume we're a court, we've had a complaint come to us, therefore we can force you to answer to it, and that's it. And that's just completely superficial. That's a superficial, arbitrary opinion. So that's what you pointed out. It's meant to be based on a valid, solid complaint.
Brad,
Go ahead, Jason.
do you mind? Right, I'll tell you what. For the benefit of anyone listening, can I suggest a scenario?
Go on.
And perhaps Fabrice, Vin, and Co can put how they would deal with it, because I think something like that would actually help people. Right, I'll tell you what. Right, when a friend of mine jumped some lights. It was sort of 3 o'clock in the morning. There wasn't anyone even about. They basically started getting these pending notices things coming through, and they wanted to see the evidence that the prosecution was relying on, i.e., a photo to prove that it was them driving. Now the police wouldn't give them a photo. Now we have a common law right to remain silent. But then he was hit with, when you don't identify the one driving the car.
Mm-hmm.
I can't quite remember what act or section it is.
172.
Sorry?
Section 172, failed to provide driver details.
Yeah, well, yeah, they want you to identify who the driver was,
Mm-hmm.
and he didn't. He was basically taken to court and done, but you've got a right to remain silent. So how can you have a statute? So I was wondering
I've got the answer to this, and funny enough, Peter and his brother and I were talking about this morning about something that
we're just blowing a hole in this one.
We were running parallel not schemes. That's the wrong sort of fucking word. But we were running parallel. Sorry.
Solutions.
Yeah. Yeah. Pete, do you want to explain it? Might as well. I mean, I'd rather not hear my voice all the time.
So section 172. Now, if you're done for speeding or something, they send you a notice of intended prosecution. that must be served within 14 days of the alleged offence. And we're getting a lot of cases come through where these are being served well outside the time. So straight away, the case is a non-starter right from go. If they don't send that notice of intent to prosecution within the 14 days. A lot of these roadwork cameras and things like that, we're getting them 2 months out of date. Yet the police are relying on people's ignorance, and they're still prosecuting these people. Well, they should be. The section 172, if you don't name the driver, it's 6 points instead of 3 on your license, and the fine is normally around the £750 mark instead of like £100 speeding fine. So we have got a little hole we're blowing in this at the present. And you'll just have to be a little bit patient because we've got a test case going through right at the moment. So fingers crossed we should be able to blow this one out of the water.
Wow.
Okay, 1 second. Bear with me. Pete, you didn't explain that very well.
Yes, sorry.
Paul, can you put your...
It's actually asking you to incriminate yourself before the driver. So they're asking you to incriminate yourself, saying, yes, I was the driver.
Yeah.
1 second.
Can I just interject a minute? Sorry.
Yeah, go on.
Yeah, regarding all that about you naming the driver and incriminating yourself, there was a case that was taken to the human rights courts in Europe. I can't remember how many years ago this was now, probably about 5 or 6 years ago, maybe longer, where this was what the argument was. There was a fellow who took it to the European Courts of Human Rights, and he argued that by forcing somebody to name themselves as the driver, they are basically incriminating themselves, which goes against the Human Rights Act, blah, blah, blah. And the judges ruled, no, as far as they're concerned with naming a driver for a speeding ticket or any such traffic offence, then it doesn't breach your human rights and it's not incriminating yourself. And there's a very famous case on that. So if you look that up on the internet, Google it, that was the ruling. Completely bonkers, completely contradictory, I know, but that's what they ruled. So as far as the courts are concerned and the the European courts are concerned, you do have to name yourself and you're not incriminating yourself as far as they're concerned. So irrespective of the logic behind that, that's what they declared. So it's not even an issue worth arguing about, really, because that's what
I was going to say, Jason, would you like us to sort of line out an interesting process to use that challenge in that case?
Yeah.
Because if you were, when you get the notices saying that you've been accused of that crime, be it Section 172 or Section 20 of the Road Traffic Act or whatever it may be, if you send back a request saying, I need more information, okay? I need the facts behind the applicability of the law. I need facts behind jurisdiction and a complaining party, and anything else that may be relevant, any camera or other, evidence that you plan to bring forward at that time, okay? Because at the earliest point there, you're asking for that jurisdiction, okay? Usually they don't respond to that. If you can get any emails, any letters, any telephone calls where they're not responsive to that, that's all worth having and sticking on a chronology for later. If you go to a plea hearing, at the plea hearing, obviously they want to get a plea out of you. You're not in a position to plea because you haven't been given enough evidence of the cause and nature of these proceedings, such as jurisdiction, the applicability of the law, complaining party, names of every witness that they want to bring against you, anything that is entirely relevant, so that you're in a position to defend yourself. Helen can explain this quite well if she wants to come in. I'm sure Vin can as well. That they need to generate a case file. For the Crown Prosecution Service to generate a case file, they need a not guilty plea placed in there. But you're not in a position to plead because you haven't entered a knowing plea, because if you haven't been given enough evidence, then they can't prove that. So it's at that point, if you can get the magistrate to put a time that the prosecution has to give you that information, so that you can have enough time to prepare for the next hearing, where hopefully, according to the criminal procedure rules, they'll want to resolve the matter as speedily as possible, be that a case management hearing or whatever, then you're starting to put the prosecution on the hook. And if you can put the prosecution on the hook with a time limit at the pre-hearing, that's fantastic. If you can't, and they enter a not guilty plea on your behalf, you have enough on record that you can get that plea stricken from the record, but that generates their case file to move forward. Either way, they can't provide that evidence within the time, and this is where Bradley suggests that you can go for a mention hearing if you have a judge or a magistrate who makes a ruling. You, prosecution, must give this evidence within 28 days, and they don't do it. It's kind of good to let the court know that, hang on a minute, they haven't proceeded with your orders. And that, again, that gets the bench and the prosecution, at odds. And that's your abusive process right there. If you have to go to a case management hearing, you can say at the case management hearing, I want, you have your application to have the plea stricken. They have to do that because they haven't provided the evidence, but the case file has been generated. You can then ask for a time limit on the evidence. Then when they don't have it, you get to the mention hearing and hopefully cut it off before you even get to a trial. And that's theoretically the jurisdictional challenge, sort of in practicality with the example that you mentioned. Does that help you at all?
Sorry,
Yeah.
sorry, Kirby. Can I just bring this point up? One point you raised there. If they enter a plea for you, they enter a not guilty plea. Well, who are they to enter any plea for you?
Well, exactly. We have a set of questions. I call them side scripts, where you have your main set of questions and queries about the cause and nature of the proceedings, and making sure that things are fair, rational, reasonable. And sometimes if they may suggest, Mr. Glastonbury, I strongly suggest you get professional legal advice. So rather than them throw you off balance, you have a side script for that. So, if you want reminding of what you'd like to say in that situation, it's written down for you. And all you have to do is make a mark on your main script, and then you can go back to it after you say, I don't require legal advice. I require responsive answers to my questions.
Can I just interject, right? So, because it's actually Fabrice, you've gone at such a pace there. You went on many different subject matters, and actually one of the ones, if Peter Gilbert is still here, we could touch on. But Jason, one thing, right, I've learned. And I'm not. This is not advice, not solid. But when they give you that notice to disclose the driver,
Yeah.
I've been doing it for a few years now for people. I've just written a letter saying who the driver is.
That's right, and Bradley, that is a very important issue, because you will notice on that form they send you, the notice of intended prosecution is now combined with the section 172. Now, if they say that you've got to send it back on that form.
They're desperate to get you to complete that form.
Yes, and it's basically what it is. That form is a fishing exercise on their part to see exactly what you've got. Now, all that you are compelled to do under that 172 is just put it in writing that you were the driver. Don't put it on their forms.
Exactly, yeah. This is where I think, and I don't know this answer for sure, right? All I can tell you, the last few years, that's what uh, I've been doing. Yeah, is the adhesion comes at the point of signing that form, which mentions those relevant sections. That's what I think. But all I can say is the is the people in these circumstances. They've either got a letter back saying, "Can you please complete this form?" Blah blah blah. Can you really, really complete this form? We're going to take the court. Blah blah blah, and then it just disappears.